Welcome back to the Deep Dive. Today we are really getting into the weeds of the Model Penal Code.
That's right.
Specifically, how it tackled the, well, let's call it the messy state of common law when it came to violence that wasn't homicide.
Assault, battery, mayhem. It was a bit of a jumble.
Exactly. And the MPC tried to bring order to that chaos, creating this logical spectrum of offenses.
Graded offenses, yeah, based on clear principles.
Our mission today is to really unpack that logic. We're focusing on sections 211.1 and 211.2.
Assault and reckless endangerment.
And we want to understand how the drafters used, the actor's mental state and the actual harm or risk involved to build the structure.
Absolutely. That interplay is everything. We'll start with the baseline, simple assault.
Okay.
Then climb up to aggravated assault, which covers the more serious felony grades.
Right.
And we'll finish with reckless endangerment, a really important offense that catches dangerous conduct itself.
Before we jump in, though, maybe a quick refresher on that core tool, mens rea.
Good idea. Mens rea, or the mental state. It's fundamental to the MPC's whole approach.
It dictates so much of the grading, right?
Everything. So the MPC gives us 4 main levels. You've got purposely P, you want the result to happen.
Your conscious object.
Exactly. Then, knowingly, K, you're practically certain the result will occur, even if you don't, strictly speaking, want it.
Okay.
Then recklessly, R, this is key. You consciously disregard a substantial and unjustifiable risk. You see the risk and take it anyway.
Big difference from the next one.
Huge.
Yeah.
Negligently, N, is the lowest culpable state. You should have been aware of that substantial, unjustifiable risk, but you weren't. It's an objective standard.
Okay. PKRN.
Got it.
So how does this framework build the first level, simple assault?
Right. Simple assault, section 211.1, subsection 1. Generally, it's a misdemeanor.
And it captures a few different scenarios.
3 main paths. First, you're guilty if you attempt to cause bodily injury, or if you actually cause it, purposely, knowingly, or recklessly.
So P, K, or R,
Right.
causing bodily injury. What's bodily injury? That's serious.
No, that's the key distinction. Bodily injury is just physical pain, illness, or any impairment of physical condition. Think a punch, a shove that causes pain, not necessarily lasting harm.
Okay, so that's path 1, PKR, causing or attempting bodily injury. What's the second?
The second path involves negligence. You negligently cause bodily injury, but only if you use a deadly weapon.
So negligence alone isn't enough for assault unless a weapon's involved.
Precisely. The deadly weapon provides the necessary bump in seriousness to criminalize mere negligence here.
Interesting. And the third path?
This one's different. It's about fear. You attempt by physical menace to put someone else in fear of imminent, serious bodily injury.
Okay, physical menace and serious bodily injury. So not just any injury, but serious injury.
Correct. And serious bodily injury means something much more severe: risk of death, permanent disfigurement, prolonged loss or impairment of a function or organ.
So threatening someone with a knife in a way that makes them fear immediate, severe harm could be this type of assault, even if you never touch them.
Exactly. It brings that civil law concept of assault, the fear, the apprehension, into the criminal law. The MPC recognized that causing that kind of terror is itself a harm worth punishing.
Makes sense. Now, there's a little footnote here about mutual fights.
Ah, yes. If the simple assault happens during a fight or scuffle that both parties basically agreed to, it's downgraded.
To what?
A petty misdemeanor.
Why the leniency?
It's partly about resource allocation, partly culpability. The idea is if 2 people willingly square off, the state's interest in punishing the resulting minor bumps and bruises is, a bit less pressing than in an unprovoked attack. Doesn't excuse it, but lessens the grade.
Okay, so that's the misdemeanor level. Now let's climb that ladder you mentioned,
Yeah.
aggravated assault. This is where the MPC bundled more serious common law crimes, right?
Yes, things like assault with intent to kill or maim or commit other felonies often got rolled into aggravated assault. The MPC reserves this for felony charges.
So what's the rule for the most serious form, the felony of the second degree?
Section 211.1, subsection 2, paragraph A, this is the big one. You're guilty of this felony second degree if you either 1. Attempt to cause serious bodily injury to another.
Attempted serious harm.
Or 2. You actually cause such serious injury purposely, knowingly, or, and here's the crucial part, recklessly under circumstances manifesting extreme indifference to the value of human life.
Okay, hold on. Extreme indifference to the value of human life. That sounds serious.
It is. It's a very high standard.
How does that differ from just plain recklessness, which is only a misdemeanor for simple assault?
It's a qualitative difference. Simple recklessness is consciously disregarding a substantial risk. This extreme indifference implies a disregard so profound, so calloused, that it approaches the culpability of knowingly or purposely causing the harm.
So it's like super recklessness.
You could think of it that way. The conduct itself has to demonstrate this profound lack of concern for whether someone lives or dies. It's often seen in actions that endanger many people indiscriminately.
That seems like a potentially tricky line to draw in practice.
It absolutely is, which makes it perfect for a hypothetical.
Let's analyze the scenario then, using that FIRAC structure.
Yes.
First, what are the legally dispositive facts?
Okay. Imagine a defendant. He's in a, let's say, uncontrollable fit of rage, just furious at the world.
Okay.
He's in a public space, maybe near a loading dock. He grabs a heavy wooden shipping pallet, those big flat things, unmoored, just sitting there.
Right. Heavy.
Very. And he blindly, just absolutely blindly hurls it out into the public area. He's not aiming at anyone specific, just lashing out.
But knows people could be there.
Knows it's a public space, yes.
Yeah.
The pallet flies through the air and tragically strikes a bystander.
And the injury.
Severe. Fractured skull, leading to permanent neurological damage.
Okay, those are grim facts. What's the core legal issue here?
The issue is whether the defendant's act throwing that pallet constitutes aggravated assault under Section 211.12a. Specifically, did he recklessly cause serious bodily injury under circumstances manifesting extreme indifference to human life?
Got it. So what rule of law would a court apply here? State the rule and its elements for us.
The rule is MPC 211.12a, specifically the second prong we discussed. For this application, it requires the prosecution to prove three distinct elements.
3 elements. What are they?
1, the defendant caused serious bodily injury. 2, the defendant acted recklessly. And 3, the recklessness occurred under circumstances manifesting extreme indifference to the value of human life.
Okay, thank you. Now for the court's elemental analysis. Let's break it down element by element. How did the court apply the first element, caused serious bodily injury?
Right, so the sub-issue is, does a fractured skull with permanent neurological damage qualify as serious bodily injury?
Seems like it should.
And the analysis confirms that. The definition, as we mentioned, includes things like protracted loss or impairment of the function of any bodily member or organ. Permanent neurological damage fits squarely within that definition. So, element 1 is met.
Understood. Okay, now the second element. Did the defendant act recklessly?
Here, the sub-rule is the definition of recklessness. Consciously disregarding a substantial and unjustifiable risk.
How do the facts apply?
Well, the court looks at the act. Throwing a very heavy object, blindly, into a known public area. Was there a substantial risk someone could be hit and badly hurt? Absolutely.
Seems obvious.
Was that risk unjustifiable? Given he did it out of rage with no legitimate purpose? Yes. Did he consciously disregard it? The facts suggest he acted despite knowing the danger. So the court concludes, yes, the conduct was reckless. Element 2 is met.
Okay, that brings us to the critical third element. Did the circumstances manifest extreme indifference to human life? This is this felony trigger, right?
This is the whole ballgame for the felony second-degree charge. The court has to decide if the nature of the reckless act showed that profound disregard.
What specific facts point to that here?
The key is the indiscriminate nature of the danger created. He didn't target one person where maybe you could argue he only risked injuring that person. He threw it blindly into an area where anyone could have been hit.
So endangering a group or the public generally?
Exactly. That generalized endangerment, the willingness to potentially harm anyone who happened to be there, is what the courts often point to as manifesting that extreme indifference. It shows a depraved state of mind regarding the value of human life itself. So element 3 is met.
So after analyzing all 3 elements, what was the court's final conclusion?
The conclusion is that the defendant is guilty of aggravated assault, graded as a felony of the second degree.
Because all elements were satisfied.
Yes. He recklessly caused serious bodily injury, and the specific way he did it, the blind, indiscriminate throwing of a dangerous object into a public space, demonstrated circumstances manifesting extreme indifference to the value of human life.
That really clarifies the extreme indifference standard. Okay, so that's the felony second degree. But you mentioned aggravated assault can also be a lower felony grade.
Yes, felony of the third degree. That's covered in paragraph B of 211.12.
And how does that work? What if the injury wasn't serious bodily injury, just regular bodily injury?
That's where 211.12b comes in. A person is guilty of aggravated assault as a felony third if they attempt to cause or purposely or knowingly cause just regular bodily injury.
Okay, simple bodily injury.
But they do it with a deadly weapon.
Ah, the deadly weapon again. So P or K intent plus simple bodily injury plus a deadly weapon equals felony third.
You got it. The use of the weapon itself elevates the crime, even if the resulting harm is minor, like a small cut from a knife used purposefully.
Why is the weapon the deciding factor there, even for minor injury? If I punch someone purposely and break their nose, that might be serious bodily injury, making it felony second potentially, right?
It could be, depending on the severity and definition.
But if I purposely cut someone's arm with a knife, causing only minor bleeding, just bodily injury, that's automatically a felony third because of the knife.
Correct. The MPC makes a policy judgment here. Introducing a deadly weapon into an assault dramatically increases the potential danger, regardless of the actual outcome in a specific instance.
So it punishes the choice to use the weapon.
Exactly. It signals a higher level of culpability and danger to the community, warranting felony treatment even if, by chance, the injury wasn't serious.
Okay, that distinction is clear. Now, let's shift gears slightly. What about situations where someone creates a massive risk, but luckily no one actually gets hurt? The near misses.
That's the domain of Section 211.2, recklessly endangering another person. This is a crucial gap filler.
What's the rule?
It's a misdemeanor. A person is guilty if they recklessly engage in conduct which places or may place another person in danger of death or serious bodily injury.
Key phrase. Places or may place.
Absolutely.
Yep.
No actual injury is required. No fear is required. The crime is complete the moment the reckless conduct creates that specific type of danger of death or serious bodily injury.
So wildly firing a gun in the air in a populated area, even if no one is hit.
Classic example of reckless endangerment.
The statute has a really interesting part about firearms and presumption. Can you explain that?
Yes. It's very direct, designed to be memorable and send a strong message. It states that recklessness, for the purpose of this section, is presumed if a person knowingly points a firearm at or in the direction of another person.
Presumed. So the prosecution doesn't have to prove the defendant consciously disregarded the risk.
Correct. The act of knowingly pointing the gun triggers the presumption. And here's the kicker.
Yeah.
Whether or not the actor believed the firearm to be loaded.
Wow. So even if you know the gun is unloaded, pointing it at someone is presumed reckless endangerment.
Yes. The MPC drafters felt the inherent danger, the potential for mistake, the terror caused by having a gun pointed at you is so significant that the actor's subjective belief about whether it's loaded is irrelevant for establishing recklessness in this context. It strongly discourages that kind of behavior.
That's a powerful policy statement. Okay, we've covered simple assault, aggravated assault in its different grades, and reckless endangerment. Let's synthesize this for someone facing an exam question. How do you systematically diagnose these offenses? What's the checklist?
Okay, this is your structured approach. Think of it as a hierarchy. Always start at the top and work down.
Step 1.
Step 1. Evaluate the actor's mens rea. What was their mental state? Purposely, knowingly, recklessly, negligently. This is your first filter. If it's negligence, you immediately know you're likely only looking at simple assault if a deadly weapon was used. Otherwise, negligence generally doesn't suffice for assault.
Okay, filter by mental state first. Step 2.
Step 2. Determine the resulting harm or risk. What actually happened or what was risked? Was it bodily injury? Was it serious bodily injury? Was it just fear of imminent serious bodily injury? Or was it only the creation of danger of death or serious bodily injury?
Match the mental state to the result risk level.
Precisely. PKR, causing bodily injury, points towards simple assault, misdemeanor. Attempting, or PKR, causing serious bodily injury, points towards aggravated assault, felony second. Fear of imminent SBI points to simple assault, misdemeanor. Creating danger points to reckless endangerment, misdemeanor.
Got it. Step 3.
Step 3. Check for aggravating factors. This is where you look for the triggers that bump the offense up the scale. Was a deadly weapon used? If yes, and the intent was P or K to cause just bodily injury, that elevates it to aggravated assault, felony third, 211.12b.
Okay, deadly weapon is one factor. The other.
Was the recklessness accompanied by extreme indifference to human life? If yes, and it resulted in serious bodily injury, that elevates reckless causation of SBI to aggravated assault, felony second, 211.12a.
So mens rea, result risk, aggravating factors. What's the final step?
Step 4. Grade the offense. Put it all together. Did it happen in a mutual fight? Petty misdemeanor? Is it basic PKR causing bodily injury, or negligent BI with a weapon, or fear of SBI, or reckless endangerment misdemeanor? Was it PK causing BI with a deadly weapon felony third?
Right.
Was it attempted SBI or causing SBI with PKR plus extreme indifference felony second?
That's a really clear diagnostic path. It cuts through the complexity.
That was the goal of the MPC drafters, to create that logical tiered system based on culpability and harm.
And it seems they largely succeeded, moving away from those old, sometimes arbitrary common law categories.
I think so. The focus on mens rea and the specific nature of the harm or risk provides a much more rational framework.
Okay, before we wrap up, time for that final provocative thought.
Right. So think about how the MPC treats attempts. The commentary highlights that Section 5.051 generally grades an attempt at the same level as the most serious completed offense anticipated, unless the completed offense is a first-degree felony.
Yeah.
If you attempt a first-degree felony, like murder, the attempt itself is graded as a felony of the second degree.
The same grade as aggravated assault causing serious bodily injury with extreme indifference.
Exactly the same, Cook. So here's the thought. How does this policy choice, punishing an attempted murder just as severely as an extremely reckless completed assault that causes grave injury, influence a prosecutor's strategic decisions? When they have a case that's almost murder, but maybe lacks the clear P or K intent for it, how does having this high-grade aggravated assault option or the equally high-grade attempted murder option affect charging choices and plea bargaining? Something for you to chew on.
That definitely adds another layer to understanding the practical application of these grades. Food for thought indeed. Thank you.
My pleasure.